Good evening. This is a special edition of Frankenfoot Theater, and I'm going to be reading a selection from John Giuca's blog entitled Black Robes, White Lies. This is posted on Thursday, April 20th, 2017. The United States Constitution, the Sixth Amendment. In all criminal prosecutions, accused shall have the right to a trial by an impartial jury. The 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law, nor deny any person the equal protection of the laws. The New York State Constitution. Article 1, Section 2. Trial by jury in all cases in which it has heretofore been guaranteed by constitutional provision shall remain inviolate forever. When I read our Constitution, I say to myself, where is this place that this document speaks of? This sounds like a wonderful place. I wish I knew where it was. Besides, for our Constitution and our laws, we have something called case law. The decisions that Supreme Court judges make were meant to have a binding force and set precedents. These decisions, in essence, become established law and set guidelines for a wide range of issues, procedures, and laws. This helps clarify complicated subjects and helps future courts reach fair, sensible, and well-reasoned results. It also helps society and lawyers predict the future course of a court's ruling, therefore preventing them from putting in frivolous suits and motions and clogging the system. The definition of the word precedent is an earlier event or action regarded as an example or guide to be considered in subsequent similar circumstances. Second definition, law, a previous case or legal decision that may or must be followed in subsequent similar cases. Our law says that when a decision comes from the same department, state, or federal circuit, it is binding. That means it must be followed. Anywhere you see People versus, that is a New York State case. The rest of the cases I cite are federal cases. They all apply as either persuasive or binding law. If you were eating a bowl of soup you bought from a local store and you found a dead, decomposing, rancid cockroach in your soup, would you just pluck the cockroach out? Would you tell yourself it's fine and continue to eat after you pluck the bug out? Or would you throw the bowl of soup away because it was tainted and get yourself another meal? In my situation, there is no new meal, and they didn't even pluck out the bug. They have forced me to eat this poison while acting as if there is nothing wrong with it, but that's enough of the metaphors. Here are the facts. My mother went undercover and recorded a juror, Jason Allo, admitting to egregious juror misconduct. The law in New York states that what my mother did is totally legal. You are allowed to record any conversation that you are a part of in New York. You are allowed to record a conversation with a third party, unbeknownst to that other person, as long as you are taking part in said conversation. In essence, all you are doing is recording your own conversations with other people. What you cannot do is place a recording device somewhere and leave the room in order to record the conversation of others. You cannot place a bug on a phone or in a room if you are not part of the conversation. This is considered eavesdropping or illegal wiretapping. This is the reason why police need a warrant to put a bug on your phone, but they don't need a warrant to strap a wire to an undercover cop and have him go on a sting operation. Buy and bust drug sting operations happen every day in this country without a warrant. So all my mother did is the exact same thing cops do on a regular basis to expose the truth and achieve justice. They use technology to have evidence of the truth and create a record of the events. Just imagine that you're in a situation where you are confronted by a mugger or an aggressive police officer and you have a chance to turn on your phone without anyone seeing you. Would you record this possible criminal conduct or official misconduct? When my mother went undercover and befriended Jason Allo, he eventually admitted that he snuck onto the jury just to convict me. He told my mother that he shouldn't have been in that jury, because technically by law, if I knew that shit, I shouldn't have been even been in that jury. What Jason Allo was referring to was the fact that he knew my circle of friends and acquaintances, the fact that he knew people on the witness list and kept silent about it, even when directly asked. The presumption that he knew facts about the case that were not presented at trial. The fact that he was influenced by an outside party several times before and during the trial. The fact that his brother also knew people mentioned during trial and had a hostile relationship with those people, who were described as my friends during trial. Jason Allo also admitted that he knew he could get into a lot of trouble for what he had done by essentially covering up his knowledge and connections to people involved in this case. In order to slip through the vetting process and push the rest of the jury into a guilty verdict. Trial court's flat refusal to hear evidence of misconduct the jurors offered by defendant's attorney was abuse of discretion. People versus Darling. A juror who lies her way into a jury is not really a juror at all. She is an interloper akin to a stranger who sneaks into a jury room. Dyer versus Calderon. Court's implied bias, where lies in jury selection imply that juror concealed material facts in order to secure a spot on particular juror. Fields versus Brown. After I brought all this damning evidence and much more which I'll discuss further, Judge Maris wouldn't even grant a hearing to listen to the evidence. He summarily denied my motion without a hearing, even though my evidence was the best kind of evidence anyone could ask for. The offending juror's own tape-recorded words. I had it from the horse's mouth and was still denied. If this situation was reversed and a juror who knew the defendant's friends snuck into a jury in order to acquit an defendant, he would be indicted, especially if he was caught on tape admitting that he committed misconduct, lied under oath during jury selection, and covered up his knowledge of people and places that were discussed during trial. But when a regular kid with no power exposes this, his mother is ridiculed by the press and his life is snuffed out. The standard for a case like this comes from the McDonough case. McDonough says that a conviction must be reversed where the juror concealed facts which would cause the court to question whether it was objectively possible for the juror to be impartial, or whether the correct answer would have provided a valid basis for a challenge for cause. McDonough Power Equipment Company Incorporated versus Greenwood. A challenge for cause is something that happens during jury selection. Let me explain. During jury selection, the judge said, "If you have heard or read anything about this case, please raise your hand to let me know." One prospective juror informed the court that he had heard rumors about the case in the neighborhood and was promptly excused for cause. That's a challenge for cause. Jason Allo remained silent. Several other jurors were also excused because they were exposed to this case in one minor way or another. A movement who makes a sufficient showing of McDonough-type irregularities is entitled to the court's help in getting to the bottom of the matter. United States versus Tucker. A defendant asserting juror misconduct is entitled to a hearing upon assertion of facts indicating juror misconduct. People versus Irizarry. After I did my research, I found hundreds of cases where a juror only did one of these things that Jason Allo did, or cases where the juror misconduct was much less severe, and the defendant was given a new trial. There are literally hundreds of cases that set the precedent before me, and dozens of cases that were reversed after me. Here are some examples of quotes from those cases. The court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. Smith versus Phillips. It is error to summarily deny defendant's motion to set aside verdict on ground of juror misconduct without first holding hearing to make findings of fact essential to determination thereof. People versus Richardson. If there is doubt as to whether a juror can remain fair and impartial or is otherwise unqualified, the court must inquire further to clarify the person's position. People versus Henderson. We explained that the trial court should conduct an in-camera proceeding in the presence of the attorneys and defendants, with the attorneys participating if they so desire. We noted that this proceeding should be a probing and tactful inquiry into the unique facts of each case, including a careful consideration of the jurors' answers and demeanor. People versus Buford. In essence, the right to jury trial guarantees a fair trial by a panel of impartial, indifferent jurors. The failure to accord an accused a fair hearing violates even the minimal standards of due process. Irving v. Dowd. When confronted by evidence suggesting possible juror misconduct, it is better practice for a trial court to hold a hearing. People v. Pollock. Preservation of the opportunity to prove actual bias is a guarantee of a defendant's right to an impartial jury. Frazier v. United States. There exist several cases that were reversed because a juror was exposed to prejudicial media accounts. This one issue, standing alone, is reversible error. This is what the higher courts say about improper outside influence on a juror. Generally, a jury verdict may not be impeached by probes into the jury's deliberative process. However, a showing of improper influence provides a necessary and narrow exception to the general proposition. People v. Mara. Third-party communications with jurors regarding substance of trial are presumptively prejudicial. U.S. v. Caldwell. In a criminal case, any private communication, contact, or tampering, directly or indirectly, with a juror during a trial about the matter pending before the jury is forbidden. Remmer v. United States. Also see Maddox v. United States. Forbidding private communications between jurors and third persons if said conversation is possibly prejudicial. The burden rests heavily upon the government to establish after notice to and hearing of the defendant that such contact with the juror was harmless to defendants. Turner v. Louisiana. Jurors must not engage in discussions of case before they have heard both evidence and court's legal instructions and have begun formally deliberating as a collective body. U.S. v. Resco. There is a strong distinction between intra-jury communication and extra-jury influences. Specifically, intra-jury communications pose a less serious threat than do extra-jury influences. McDonald v. Urkel. Fundamental to the judicial system's administration of justice is a fair and impartial jury. A jury should reach a verdict that is based solely upon the evidence admitted at trial. U.S. v. Montez. Jury's verdict can be impeached by delving into deliberations of jury where verdict was alleged to be proper product of improper influence, outside influence. People v. Thomas. Doubts regarding juror bias must be resolved against the juror. Byrne v. Johnson. In Stockton v. Commonwealth of Virginia, prejudice was found when the owner of a diner where jurors were dining said to jurors, "I hope you fried it, son of a bitch." Jason Allo admitted to outside influence when he confessed that he spoke to his boss, and his boss didn't want to give him time off for jury duty until he explained which case he was selected for. At that point, his boss gave him the time off, told him he would take care of him, and expressed that he wanted to see that fucking kid fry. He admitted reading prejudicial newspaper accounts and watching news reports about the case even after the judge instructed him not to. He talked about an extensive conversation with his cousin where she relayed neighborhood gossip from someone who knew us both. This person believed I was guilty based on media accounts and told Jason, Allo's cousin, his opinion. When Allo's cousin told him about this, Allo believed he was getting inside information off the record and believed it to be accurate because the source acted as if he were very close to me when in reality he wasn't. Allo is on tape saying, "My cousin wouldn't lie about something like that." Outside influence is the most prejudicial form of juror misconduct. In U.S. v. Marie, actual prejudice was found where juror receives ex parte advice from juror's friend regarding petitioner's guilt. The right to a trial by an impartial jury lies at the very heart of due process. Irving v. Dowd. Our common law heritage, our Constitution, and our experience in applying that Constitution has committed us irrevocably to the position that the criminal trial has one well-defined purpose: to define a fair and reliable determination of guilt. Estes versus Texas. That purpose simply cannot be achieved if the jury's deliberations are tainted by bias or prejudice. Fairness and reliability are assured only if the verdict is based on calm, reasoned evaluation of the evidence presented at trial. Thus, time and time again, in a broad variety of contexts, the court has adopted strong measures to protect the right of trial by an impartial jury. Smith versus Phillips. Even if only one juror is unduly biased or impartial or prejudiced, the defendant is denied his constitutional right to an impartial jury. Tinsley versus Borg. Obviously, the first impartial did not belong in that. To summarize, the court has required inquiry into prejudice even when there was no evidence that a particular juror was biased, has regarded the absence of a balanced perspective and not simply the existence of bias against the defendant as a cognizable form of prejudice, has strongly presumed that contact with the juror initiated by a third party is prejudicial. Smith versus Phillips. The court has regarded against conduct by third parties that might affect the juror's impartiality. Remmer versus United States. It ruled that any communication with a juror during trial about matter pending before a jury is, for obvious reason, deemed presumptively prejudicial. Verdict will be impeached upon a showing of improper influence. People versus Anderson. If only one juror is improperly influenced, the defendant is denied his Sixth Amendment right to an impartial panel. United States versus Hendricks. Courts should conduct full inquiry into bias where circumstances suggest such inquiry is appropriate. In these cases, the court regarded actual bias as including not only prejudice in the subjective sense, but also such as might be thought implicitly to arise. United States versus Wood. Given the great potential for harm and the importance of the right of an impartial jury to an impartial jury, doubt should be resolved in favor of the defendants. Peters versus Kiff. Trial by fair and impartial fact finders is the heart of what we claim justice in America is all about. Dyer versus Calderon. Young female committed misconduct identical to what Jason Allo did in my case. Jason Allo also admitted to having a racial bias against me because he thought I was Jewish and he hated Jews. He also admitted to lying about jury selection and having an axe to grind against me because he felt some guys I hung out with in Bensonhurst bullied his brother. He also admitted realizing he knew people involved in the case and didn't inform the court. The judge repeatedly emphasized that jurors were prohibited from reading or listening to any media accounts or discussing the case with anyone during trial. This happened at least 11 times. Jury selection, page 141, trial transcripts, page 19, 170, 230, 629, 740, 764, 892, 906, 1027. Jason Allo refers to this rule as bullshit and said he saw them. Bias should be implied in new trial granted when juror conceals information that would have resulted in disqualification for cause. McCoy versus Goldston. Disqualify any person who has a relationship to a person or witness to the action which is likely to preclude that person from rendering an impartial verdict. New York Criminal Procedure Law. Presence of biased juror cannot be harmless. Error requires new trial without showing of actual prejudice. U.S. versus Hyatt. Juror who stated unequivocally that she was racially biased should have been dismissed as grossly unqualified to serve. People versus Rodriguez. A juror is grossly unqualified when it becomes obvious that the particular juror possesses a state of mind that would prevent the rendering of an impartial verdict. People versus West. If the court finds that the juror is grossly unqualified to serve, that juror must be dismissed. Criminal Procedure Law. If answers to the following questions during voir dire, jury selection, are willfully evasive or knowingly untrue, the talesman, when accepted, is a juror in name only. His relation to the court and to the parties is tainted on its origin. It is a mere pretense and sham. Justice Cardozo and Clark versus the United States. When possible, non-objectivity is secreted and compounded by deliberate untruthfulness. A potential juror's answer on voir dire results is deprivation of defendant's right to fair trial. U.S. versus Colombo. Bias or prejudice is such an elusive condition of the mind that it is most difficult, if not impossible, to always recognize its existence. And it might exist in the mind of one on account of his relations on one of the parties, who was quite positive that he had no bias and said that he was perfectly able to decide the question wholly uninfluenced by anything but the evidence. Crawford versus the United States. Harmless error analysis did not apply to jurors' post-verdict statement that he guessed he based his decision on race even though evidence of guilt was overwhelming. People versus Estella. Reversal is warranted when a juror has an undisclosed pre-existing prejudice that would have resulted in his or her disqualification if it had been revealed during voir dire, such as an undisclosed pretrial opinion against defendants. Grave doubt persists whether the verdict was tainted by prejudice and bias. If so, the jury finding is suspect, and the defendant did not have a fair and impartial trial. People versus Whitmore. Juror's statement indicated hostility to racial minorities that cast doubt on his ability to render impartial verdicts. And an unequivocal declaration that his bias would not influence verdict, he could put aside personal feeling, keep open mind, and render impartial verdict on evidence presented fell short. Reversed. People versus Blyden. Prejudice or racial bias in any of its ugly forms has no place in an American court of justice. It destroys the concept of fundamental fairness. It steals from the accused full and equal protection of the law and strips him of these safeguards guaranteed and secured by the Bill of Rights and the provisions of the Constitutions, both federal and state. Failure to act in a case that raises grave doubt of suspected conduct that made a fair and impartial trial an impossibility would violate every principle of fairness and decency. The obligation of the court is clear. Any concern expressed in disturbing the verdict of a jury must be subordinated to the rights of the accused when the court is convinced that he has been deprived of one of the constitutionally guaranteed absolutes. Deprivation of the absolute right of the accused to a fair and impartial trial reduces the process of law to a mere sham. Mooney versus Holohan. Bias or prejudice in any form, destroys the hope of fundamental fairness and undermines the constitutional provisions of the 14th Amendment Clause of the Federal Constitution. People versus Whitmore. Jason Allo, that was a Freudian slip, I guess, also said to his boss, "This is something I gotta do," and admitted that he was so fucking eager to do it. Does this sound like an indifferent, impartial juror? This is what the Supreme Court had to say about that. Jury service is a civic duty that citizens are expected to perform willingly when called upon to do so. But there's a fine line between willing to serve and being anxious, between accepting the grave responsibility for passing judgment on a human life and being so eager to serve that you court perjury to avoid being struck. The individual lies in order to improve his chances of serving, has too much of a stake in the matter to be considered indifferent. Whether the desire to serve is motivated by an overactive sense of civic duty, by a desire to avenge past wrongs, by the hope of writing a memoir, or by some other unknown motive, the excess of zeal introduces the kind of unpredictable factor into the jury room that the doctrine of implied bias is meant to keep out. Judge Kaczynski and Dyer. The right to a jury trial is a bulwark of liberty enshrined in the Constitution. Courts need to ensure that tainted jury verdicts, even those reached after long and costly trials, do not stand. U.S. versus Dogadas. Allo believed that some higher power guided this case to him. The serpent, maybe. Allo also said the case had been presented to me for a reason. Actual justice did not matter as much as the appearance of justice, and that's why they were able to run roughshod over the Constitution, as long as they were able to expertly guide into the narrative. A lawyer by the case of Stiles Rizzullo contacted Jason Allo, offering to represent him pro bono for free. This lawyer just so happened to have received an award from the Brooklyn DA's office a short time before this incident. It's rare that defense lawyers receive awards from their adversaries. They go on a media blitz to discuss whether or not Jason Allo slept with my mother. Even though Allo says he did not, the discussion becomes the main focus of the narrative, and the real issue falls by the wayside. Judge Maris then throws a cloud of suspicion over the authenticity of the recordings, saying we have no way of knowing if it was really Jason Allo's voice on the tape. Even though Allo himself just appeared on multiple showings, admitting it was indeed him on the tapes. Judge Alan Maris denied me in a 21-page decision where he totally ignored clearly established federal and state law. Instead, he used a classic diversion tactic to spin the issue and control the conversation. He basically said that there ought to be a law to protect jurors from people like me and my mother. He totally dodged the actual issue. The fact, I didn't get a fair trial. When he pretended to address it, he misapplied the law. My lawyer's response to the New York Law Journal was, your job was to apply the law, not make it up. I couldn't understand why a judge who didn't have a horse in this race would twist such a clear-cut violation of constitutional rights and set-in-stone precedent. After all that hard work my mother went through to unearth the truth and expose my tainted and erroneous verdict, Judge Maris showed us that he is nothing more than a prosecutor wearing a black dress, presiding over a kangaroo court. My mother and I were crushed, and when I was called down to a visit, I found her crying so hard I thought someone died. She came to visit me to give me the news of the denial, and our emotional roller coaster descended back down to the depths of hell. Not only was I wrongfully convicted, but now they were ignoring their own criminal procedure in order to preserve my wrongful conviction. It wasn't until later, that I found out why Judge Maris was complicit in destroying my life and casting me into a never-ending nightmare without losing any sleep over it. At the time of his decision in 2009, his son, Justin Maris, was in law school. Shortly after my unjust decision by Alan Maris, his son, Justin Maris, was given a job as assistant district attorney at the Brooklyn District Attorney's Office during when Charles Breezy Point Joe Hines was in office. It turns out I was wrong about one thing. Judge Maris did have a horse in this race. I'm hopeful that after these miscarriages of justice, that John Giuca will be sent home on May 1st, 2018 to his family and his loved ones and his friends. I hope I'm going to be there. I hope you'll join me. Thank you. This has been a special edition of Frankenfoot Theater. This is for John Giuca. Have a great day.